The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. My name is Judge Marguerite Grant, and with me today are Judge Robert Brennan and Judge Robert Toone. This is the sitting of the Massachusetts Appeals Court on Tuesday, January 14th, 2025. We have one case on Zoom, and then we will go to the courtroom to hear 5 more cases. Just to explain, each side has 15 minutes to argue. I understand that the Attorney Woolley for DOC will be going first, and then Mr. Gaskins will be arguing on behalf of all 3 plaintiffs. Each side gets 15 minutes total, and there will be a timer that goes off counting down that you'll see on your screen. After the argument of the opposing side, or during the argument of the opposing side, please keep your camera on, but please mute yourself and try to keep any facial expressions to a minimum. With that, I will call the first case. It is Appeals Court 2024 P503, Tony B. Gaskins and others versus Carol MICI and others. Mr. Woolley.
Good morning, and may it please the court. Good morning, Justices Timothy Woolley for defendants appellants, former Commissioner MICI, Superintendent Dean Gray, and Deputy Superintendent Patrice Holloman. Your Honors, the question before the court today is whether the Superior Court abused its discretion when it entered a preliminary injunction that lacked adequate factual support, was based on clear error of law, and that ordered the Department of Correction to operate in a manner that would create grave security concerns across all institutions. Your Honors, the answer to that question is a clear yes. The Middlesex Superior Court's preliminary injunction in this matter primarily concerned behavioral assessment units within Department of Correction institutions. At the time this case was filed, all 3 plaintiffs were held in the behavioral assessment unit at MCI Concord in Concord, Massachusetts. Despite this case only concerning the BAU at MCI Concord, the Middlesex Superior Court issued a sweeping and overbroad preliminary injunction that applied to all incarcerated individuals held in quote-unquote segregation for more than 90 days. This touched on units that were not part of the record below, and moreover, just with respect to the BAU at MCI Concord specifically, there was not adequate factual support for the Middlesex Superior Court to reach that conclusion, even with respect only to the BAU at MCI Concord.
Mr. Woolley, just what's the basis for interpreting the judge's order as applying to all facilities? Because I look at the February 12th endorsement on the motion to stay order, and it says immediately release all inmates, including named plaintiffs. But it doesn't say all inmates at all facilities. It really doesn't specify one way or the other whether it applies to facilities other than MCI Concord. So how do you get to sort of this is a global injunction that the judge entered?
It's really that language, all inmates, Your Honor. And the department found that the language of the preliminary injunction lacked clarity and sought the Superior Court to clarify the order. We moved for reconsideration and sought clarification. However, where it just states all inmates and it does not state all inmates at MCI Concord, it does not state all inmates in a BAU, there was concern that just that language, all inmates, could be broadly interpreted to apply to all inmates across all department institutions, which is why we sought clarification from the Superior Court, which was not provided in this matter.
So even the follow-up order was ambiguous as to that point, correct? I totally understand it could be interpreted to sort of mean all inmates in the department's custody, but it could also be interpreted to mean all inmates at MCI Concord, which will still raise other issues, but there'd be a clearer way to sort of resolve this case if we interpret it that way, because MCI Concord is now closed. Is that correct?
That is correct, Your Honor. MCI Concord is now closed, and those incarcerated individuals that were housed there have been transferred to other department institutions.
Did the plaintiffs specify whether they were seeking relief beyond MCI Concord in either their complaint or their motion for preliminary injunction?
They did not, Your Honor. And in fact, plaintiffs did not even seek the relief that the Superior Court ultimately granted in this case. The Superior Court went beyond the relief that plaintiffs were asking here. In the department's brief, we cite to the oral argument transcript in which Mr. Gaskins states that they're not even seeking a release from the BAU. They're more so they were seeking a restoration of privileges that they alleged that they were entitled to in the BAU. Despite this, the Superior Court went beyond what plaintiffs even asked for and ordered the immediate release of all those individuals, whether that be individuals in a BAU or department-wide held in segregation, as was the language used by the Superior Court. Now,
just to follow on Justice Toone's question, just in context, how could that order be read as applying to anyone other than those at MCI Concord?
Because, Your Honor, the order, as the plain language of the order, just stated all inmates, and it stated all inmates held in segregation. The department argued, assuming that the Superior Court was using segregation as a synonym for restrictive housing in this instance, as has been done in past court cases, it was the department's argument that both the MCI Concord BAU does not constitute segregation, and moreover, that the department no longer uses segregation or restrictive housing at any of its institutions. However, it was entirely unclear from the court whether it had made a finding that the MCI Concord BAU constituted restrictive housing, whether it made a finding that all BAUs constituted restrictive housing, whether it made a finding that all SAUs, secure adjustment units, constituted restrictive housing. So that point was entirely unclear from the preliminary injunctions, and potentially would result in a gravely dangerous situation for the department, considering that behavior assessment units are used to house individuals who department staff determine pose a significant safety and security risk to the orderly operations of department institutions. These units may also house individuals who claim that they have a personal safety need that the department needs to investigate, i.e. Protective custody, essentially. And so immediately releasing those individuals without any sort of hearing or anything along those lines, per the preliminary injunctions orders, would create a gravely dangerous situation, not only for incarcerated individuals, but for department staff as well. There is a reason that those individuals were determined to have a need to be held in the BAU, and the preliminary injunction contravened the judgment of correctional officers and correctional administrators in this instance, and did not give due deference to them. I would also just note that with respect to the lack of clarity as to whether or not the BAU or any other unit was restrictive housing, there was not adequate factual support in the record for a finding by the Superior Court that the BAU or any other unit was restrictive housing. That is noted by Justice Dickoff in his single justice opinion in this matter, which stayed the preliminary injunctions, noting that none of the affidavits submitted by plaintiffs nor any of the verified complaints submitted by plaintiffs alleged that they were indeed being held in a cell for more than 22 hours a day. That is the definition of restrictive housing per Mass General Law, Chapter 127, Section 1. And to the contrary,
and that's because your policy is that they get out, they only spend 21 hours in their cell under policy. Is that correct?
Respectfully, Your Honor, that is incorrect. The policy requires that incarcerated individuals in these units are offered a minimum of 3 hours out of cell for recreation, which would be the 21 hours that you're referring to. This does not include additional time out of cell for visits, for showers, for programs, for hair care services, and things along those lines. So 21 hours is the baseline minimum when you consider just the recreation portion, both indoor and outdoor recreation, but there are also other opportunities for individuals in these units to be out of cell. And Patrice Holloman did submit an affidavit that was part of the lower court record confirming that these individuals are offered a minimum of 3 hours out of cell per day for recreation time. And there was nothing in the record by plaintiffs to refute that. Therefore,
I
it was
understand your point about there not being an adequate record here for these issues, but it does seem like there's at least a potential for litigation involving the intersection of the department's current policy on behavioral assessment units and secure adjustment units and the Criminal Justice Reform Act and LaChance and other issues. So can you just give us an overview? Are any of these issues being challenged elsewhere in the Commonwealth? Right now?
Absolutely, Your Honor. They are. There is currently a class action in Suffolk Superior Court. That is Evelyn versus Jenkins. And that is case number 2484 CV 01746. That case is still in the initial pleading section phase. And I would also just note
Are the prisoners represented by counsel in that case?
They are. They're represented by numerous counsel, including Prisoners Legal Services and other counsel. Your Honors, I would also just note, with respect to Justice Toone's question, that the department did promulgate new policies, updated policies with respect to the BAUs and SAUs on January 6th of this year that provide more robust due process protections for individuals housed in these units, namely that those individuals housed in these units now have an opportunity to appear directly before the IAT, the interdisciplinary team that makes the determination of whether or not they will remain in those units, at least with respect to the BAU, every 60 days.
So that was to deal with what Judge Ditkoff had noted was a concern about even the prison's description of the conditions with respect to LaChance hearings would make out an atypical and significant hardship.
That was certainly a consideration in updating those policies, Your Honor. Although whether or not the prior policy offered adequate due process protections has not been fully litigated to this point, in an effort to head off future concerns or future litigation, the department did update its policy to ensure that individuals housed in BAUs are afforded an opportunity to appear in person directly before the board every 60 days. The prior policy allowed that individual to appear in person before a correctional program officer who then essentially relayed written and oral statements from the individual to the ultimate deciding authority, which could include that correctional program officer as well. So the old policy essentially allowed the individuals to appear before a portion of the board or a portion of the deciding individuals, but not necessarily the full panel.
How does that new policy intersect with the 90-day placement review, which appears that the department put in place on February 12th, 2024? Is that still, are those 90-day reviews still going on, or has the 60-day process taken its place?
The 60-day processes have taken the 90-day reviews place, Your Honor, as of January 6th of this year. It's the department's position that the 60-day processes afford the same level of due process as the 90-day placement reviews did, except they're occurring more often. They're occurring every 60 days as opposed to every 90 days under the prior 423.09 policy. And just in further...
Okay, let me just ask, and is the adequacy of these hearings under LaChance and Sandin versus Connor and other cases, is that one of the issues that's being litigated in Evelyn?
It is, Your Honor, as to whether or not the department BAUs and department SAU level 4 constitutes restrictive housing, and whether or not the due process protections in place under the prior policy satisfied LaChance, satisfied the CJRA, et cetera. And just going back to your prior question, Justice Toone, with respect to ongoing litigation, the department has had several other cases brought where decisions have been made finding that department BAUs are not restrictive housing, cases with far more developed factual records than the case before the court today. And I would just like to point those out to the court briefly. One case is Wright versus WRIGHT versus DOC, and that was in Suffolk. That's case 24-02218. Superior Court Judge John Pappas on December 20th of 2024 found that MCI Norfolk no longer uses restrictive housing. He found that the DOC stopped using restrictive housing at all male medium security facilities as of April 2022. And as of June 2022, Judge Pappas found that the DOC does not use any form of restrictive housing at any institution. Another case where DOC received a favorable ruling with respect to the BAUs not being restrictive housing, or SAUs in this case, excuse me, involved one plaintiff in this case, Mr. Gaskins. That's Gaskins et al. Versus MICI et al. And that's Middlesex, case number 19-03003. In that case, plaintiff's case was dismissed in the court. Judge Paul Wilson on August 5th of 2024 found that the plaintiffs had conceded that those in the MCI Concord SAU were not confined to their cells for more than 22 hours a day, and thus that unit was not restrictive housing. Two other cases. One was Pace versus MICI et al. That was a Suffolk case, 24-001520. On June 26, 2024, Judge Jackie Cowan denied plaintiff's motion for preliminary injunction and found that the Norfolk BAU did not constitute segregation, and also found that the plaintiff had received adequate due process in the form of 60-day appraisals and 90-day placement reviews. I see my time is running short, Your Honors, if I may conclude with just this last pending case.
Just the last case, you can give us that.
And the last case is Rosa Quintana versus MICI et al., and that was a Worcester Superior Court case. Docket 23-00147. That was Judge Karen Goodwin, on April 4th, 2024. She denied plaintiff's motion for motion on judgment on the pleadings and allowed defendant's motion for judgment on the pleadings. And she found that the established BAU appraisal process, i.e. giving notice to incarcerated individuals of the appraisal and allowing them to speak on their own behalf regarding their placement in the BAU, did not violate any due process requirements for those units. For those reasons and the reasons stated within our brief, Your Honor, we do ask that you vacate the preliminary injunction of the Superior Court and remand for vacate and or dismiss that preliminary injunction. Thank you all for your time.
Thank you. I understand Mr. Gaskins is trying to get his mute turned off.
Okay, can you hear me now?
Thank you. Mr. Gaskins, good morning.
Yes, Your Honor, good morning. Good morning. Okay.
Good morning.
In counter to what was just said is just the craziest thing. All right, so let's start from how this whole thing began. We're all in non-disciplinary segregation. This is administrative segregation, no matter what type of name you put on it. It's restrictive housing, SMU, whether if it's DDU, 10 block, 9 block, or whatever name you want to give it. It's administrative segregation, which is solitary confinement. So we're in solitary confinement, separated from the general population. So no matter what type of time out of cell, we're in restraints, we're chained to tables. When we have our video visits on the phone, we're chained to the table. We're only one hand free to talk on the phone. This is segregation. We're in a cage, in a kennel cage by ourselves. We got non-contact visits. This is in violation of what the laws in this state says. In this state, we got 2 laws that regulates how prison segregation is supposed to run. Whether if you want to call it restricted housing or whatever name you want to get it, whether it's BAU or SAU. And that's General Law Chapter 127, Section 39, that the legislature wanted to change how segregation was to be conducted in the state of Massachusetts, and they wanted to change how we knew it into a better form, in a more reformative way. In 103 CMR 421s, these are what regulates segregations in Massachusetts. And none of these regulations are being complied with. When the 421s came out, and Haverty City came out in 2012, MCI the Junction was being ran on the Maxon like a DSU. And Haverty ruled that you cannot place these men under these type of conditions. And if you look at how it was ran in Walpole, a whole bunch of guys was coming out together. Nobody was segregated, but it was under DSU-like conditions. So this is what we're talking about in this particular case. And this is what Judge Friesen understood when we put the injunction before. Now, when we said in the injunction, we asked very specifically for the injunction out of her order for prisoners following segregation on awaiting action within the Department of Correction, including but not limited to behavioral adjustment units and whatever named segregation units within the Department of Corrections. That's what we asked for in the injunction.
Hey, can I ask a question, Mr. Guy? Can I ask a question? Did you specify that you wanted relief to units outside of MCI Concord, or did you not specify either way?
Well, what we specified in the BAU, whether if it's the BAU in Concord or wherever it's at, BAUs are BAUs. They all got the same conditions and same treatment. So I could easily be transferred from that BAU to another BAU, and I'll still be under the same conditions. So I would believe that it wouldn't just apply to the Concord BAU, because if that was the case, when Haverty moved on MCIC the Junction, then it would only apply to people in MCIC the Junction and no other facility, and that's just not the case in Haverty. Nor was it the case in the Chance, when you're put under these like conditions. So when the Chance was moved on, it applied to all DOC administrative facilities. If you put guys under these conditions, this is the process they are doing. Now, in this particular instance, 12739B 1 through 10 put what we are entitled to. This is the entitlement. This ain't no discretionary term that the DOC has to do or not do. This is a mandate from the legislature. This is what they intended to have occur, because they wanted to change of how segregation was to be conducted in this state. As well, in the 421s, it was very, very clear when they tried to repeal it in 1995, the courts weren't allowed to repeal it. So under the 421s, it says the protections that we are entitled to when we're placed on awaiting action, which that's what we were. So we weren't in a DSU environment. We were supposed to be awaiting action, which only have a 15-day maximum, 30-day maximum criteria by our rules. Not 60 days, not 90 days, and nothing like that. In order to put a person under DSU-like conditions in this state, you have to first get found guilty of a disciplinary report. Then the superintendent has to deem you a threat to go back in the population and make that transferable to the commissioner, who then have to determine if there's such a threat that you have to be put before some type of board to be placed in further isolation. Therefore, when you're put under those conditions, you're entitled to the protections of the 421s in section 39B. This is just how it is. So this is what Judge Friesen understood when we put the injunction before what we were suffering from. We were in segregation way over 90 days. We never got one single hearing. And under the chance, it very clearly says if a person, no inmate may be in there beyond 90 days without a hearing. So when the chance decision came down in 2012, the DOC adhered to that for a little while before they switched it up. So they would not let any prisoner stay in segregation beyond 89 days. On the 89th day, they would release you, because that's what the chance says. If you don't give nobody a hearing within that time frame, you have to release them. So Judge Friesen only ordered, based upon what the chance directed, that if they're beyond 90 days, which she says, that you have to immediately release them. That's not a danger. That's what is required by law. That's not a danger. Because
Let me ask you a question.
Yes, ma'am.
So DOC is saying that the BAU was not restrictive housing within the definition in chapter 127, section 1, because the inmates there were allowed out of their cells for at least 2 hours a day. In fact, 3 hours a day. Did your filings before Judge Friesen establish that that was not the case?
Well,
That it was restrictive housing?
My pleadings before Judge Friesen was very, very clear that we're in restrictive housing because just because what happened is that Representative Day sent a letter saying that the DOC is circumventing the CJRA by giving us an additional half hour out in the segregation units. However, we're in the same units that SMU, RHU, 10 block, 9 block. These are the same segregation units that they just changed the name. So it doesn't change our conditions. And this is all about conditions of confinement. So when you're a non-disciplined prisoner in segregation, you're entitled to certain privileges, rights, and benefits as if you're in general population. One of the things that was very clearly outlined by the legislature in 12739B, and what was clearly outlined in 103 CMR 421 20 sections 1 through 11, very, very clear that we're entitled to the same canteen rights in general population. We're entitled to have our TVs in segregation. We're entitled to programs. We're entitled to vocational. We're entitled to good time. We're entitled to work opportunities. We're not getting none of it. We're just sitting in a cell with nothing. We're stripped of everything under harsh conditions, and we're subjected like we're being punished. We're under punitive conditions without actually being considered a threat. So here's what I'm saying. So what 103 CMR clearly states is that the 421s clearly state that we have to be deemed a threat before we're put under those conditions. And then once we're classified as a threat, then we got to be put into this condition, in this placement, and served there for that amount of time. And we got a 90-day interval between time that we have to keep assessments from that aspect. None of this is being done. So when you put me in this environment, you're supposed to give me my protections, the protections that is mandated, not discretionary. So the protections are, if I'm in here, you got to treat me because I'm administratively locked up. I'm not punitively locked up. And if I'm punitively locked up in there, you only can punish me for 15 days. Well, what they do inside that, which I point out, is that they're giving guys sanctions, 120 days lost, and they compile it. So a guy could be in there for 9 months and do 9 months worth of sanctions. And that's what the law says you can't do in those conditions, in that environment. And that's what they're doing. So they're doing what they've been doing since the 80s, since the 421s came into place. They find ways to circumvent it and work around it. That's what Judge Friesen understood. She said this is just a workaround of what the protections are entitled to the prisoners. And that's what we're arguing for. So there's no evidentiary factor.
Gaskins, can I ask you a question, sir?
Yes, sir.
So, okay, what do you say about the argument, though, that the judge just went well beyond that, and that the answer to your complaint was to fix what you complained about, not just to say, well, let everybody go, and I'm paraphrasing,
Well,
immediately.
in my order, I said similarly situated prisoners. So
Yeah.
that's the reason why she went there. Because
Okay.
I used a similarly situated prisoner analysis in there saying that people under like conditions as well as me, as myself. Because I'm in no position to file any type of class action.
Right.
So me and the other guys.
You got my point. Yep.
That's the plaintiff. We found it as plaintiffs, and I said similarly situated in whatever segregation unit they want to call it. So all she did was work within the construct of what we asked for inside the injunction. It wasn't an override. She just said, if the guys are in there past 90 days, which the chance says, you got to release them. That's what the chance says. That's the chance one. Very clear. And when she said, and restore all their rights and privileges as if they was a general population, that's what the legislative intended, and that's what the 421s combat. So she's within the construct of what our state created rights, because this is state created right. This ain't no constitutional right. It's state created, and which has mandatory predicate and criteria. So that's the reason why she was in the bounds of her discretion to make this decision and her ruling the way she made it, because we submitted our affidavits, we submitted evidence, we argued this case on both sides, so there wasn't nothing to be sought after more than what was already done at the hearing.
Mr. Gaskins, I mean, you've obviously done an impressive job litigating this case, given your ability to do so as a prisoner. I totally take your point that a pro se inmate probably can't seek class certification. You normally counsel's required for that, and I understand that you asked for similarly situated relief, or to go to similarly situated inmates as well. In general, though, right, where courts generally don't grant remedies for for the benefit of people who aren't parties to litigation. It does seem from what Mr. Woolley said that there is this litigation going on in the Suffolk Superior Court, litigated by Prisoner Legal Services, among others. And I just wanted to ask, are you aware of that litigation? Do you think that, if you are, do you think that litigation raises the same kinds of issues that you've been challenging in this litigation? I'm just curious on your thoughts about that.
Well, my thought on that is that we filed this litigation way before that litigation was filed. So we had nothing, we had no involvement in it. We was never asked about what our beliefs and intentions are on what they get ready to do in that regards, right? So I never read the pleadings, so I don't know exactly what they're arguing and what they're saying in the pleadings, but I don't think it has no bearing on what we're doing right now. Because what we're doing right now is trying to stop injustice that's going on. It's been going on for decades, since the 70s, that the DOC's been doing this. So the legislature make laws, or you act promulgate regulations, and the DOC always find a way to work around it. That's the reason why we got Hoffa. That's the reason why we got Haverty. That's the reason why we got Cantel. That's the reason why we got Longville and all those other decisions, because they keep telling the DOC, stop doing this. You cannot circumvent the legislative intent. You cannot circumvent statutory and state regulations, regulatory provisions. And that's what they just did again. When 2018 came with the new law under the CGRA, they had all the units restricted housing, and then they sat down and schemed up a way to try to work around it. So restrictive housing is absolutely obsolete. 12739 based on the DOC ain't even in effect. That's the same thing they argued back in 1995 to try to repeal the DSU regulations, saying we don't use that anymore. But the court said, no, you're putting guys under the like conditions, so those regulations apply. And that's what we're arguing here. We're saying we're under the like conditions of DSU-like conditions, very, very harsh conditions, but we have protections, and the DOC refuses to afford us those protections. So it's up to the courts to enforce what they already have enforced in the past. And in this particular case, because you're making these regulations basically obsolete. What's the purpose of having these laws if they're not going to be enforced? That's the problem. And one thing I want the court to very, very understand this, right? This is very important. This is a public safety crisis. Public safety to the core. Guys are getting released to the streets from these harsh conditions back into the public. They're supposed to be reforming and correcting these guys, putting them under a good condition to get them ready to get back out there, and they're not doing none of that. They're kicking them in the butts every day, and then they push them back out society. And what do you think that creates? This is a public safety nightmare that's going on in here, and the only person that can stop this is the courts. So Judge Friesen understood this very clearly, and all she did was just say, okay, y'all gonna give these guys these conditions until this matter plays itself out. Because the likelihood of success is one of the main criteria of an injunction. And the likelihood of success for us is founded in all the laws since 1978, from Blaine versus Commissioner, through Hoffa, through Cantel, through Haverty, all the way up until now. None of the cases were filed for the DOC in this matter. This is for the prisoners, and it's a public safety issue that y'all really, really need to think about. If you talk about lifting this, and removing this injunction should stay in place. It should not be lifted. It should be ordered that they comply within the parameters of the injunction and what Cantel says. Cantel is the last decision in 2016 that gives directives to the DOC that we're entitled to these rights and privileges and benefits, and we're not given. So this court could, ride off the spirit of Cantel and say, okay, we're going to keep the injunction in place. Even if you want to limit it, you can limit it, but we need some protections in this injunction. And I stand by the pleadings, and also the amicus that PLS give a pretty good descriptive context of what we're trying to put before the court. One last thing, is not moved. So we can't, just because we're not in there, we're capable of being putting those conditions again. So under the chance too, they made that very clear. In the pleadings that I also put inside my pleadings on appeal, make it very clear that this court can hear this matter further, even though we're no longer under those conditions, because it's a good chance we're all going to get put back in the BAU or the SU. Thank you, John.
Thank you.
Thank you. That was very helpful. So that this concludes the Zoom portion of our sitting. Thank you all very much, and thank you to the people at the DOC facilities for facilitating this.
Thank you, John.
Thank you, Your Honors.
Thank you.
Have a good day.
Good day.
Okay, take care.